Hello there, everybody, and welcome to the Trademarks Post Registration Audit Program webinar. We're very happy to have you here today. We're going to get started in just a couple of minutes, but first we have a couple of housekeeping things that we need to take care of first. By the way, my name is Jason Lott. I'm the Attorney Advisor for Trademarks Customer Outreach at the United States Patent and Trademark Office. And for those of you who've seen me before, don't worry, I'm only hosting today. We have two really great experts who are going to be talking through the program with you today. So we're going to get to that in just a couple of minutes. So just a couple of things to keep in mind, because I know someone's gonna want to ask the question, is this being recorded? And the answer is yes. Yes, it is. This session is being recorded. It's going to be posted to our website in about 3 weeks, close to a month. It kind of depends on how things go. It's going to be posted to the same event page where you probably found out about this event. So there'll be a copy of that there, as well as on the Trademarks webinar series page as well. And at the very end of the program today, I'll just show you very briefly where to find that on the website in case you just found us on Eventbrite and have never, ever been to the uspto.gov website before. Also, the slides are going to be available as well. When you logged in for the event today, you should have seen an option to download a copy of the slides. So hopefully you did that. If not, feel free to do so at any time. With regard to communicating with us today, the chat is going to be open. However, the chat feature is only going to be available for technical questions. All right, so if you're sending in a question about something that you just heard or saw on screen, it's not going to be answered. The only person you're going to be contacting is one of our excellent technical staff, and that's really only for technical issues. If you have questions about the presentation today, or about the post-registration audit program in general, instead you should send them to tm_webinar@uspto.gov. And again, that is an underscore between TM and webinar. It's not a space. So tm_webinar@uspto.gov. Send your questions there. We will not be able to probably get to all of them today, but we're going to do our best to go through as many as we possibly can. So please feel free to shoot an email to that address, and that address will be available throughout the presentation. They're going to be posting it in the chat box. So if you forget what it is, or was there an underscore, or was there not, it's going to be available in the chat. You'll be able to see it there. If you need captioning, that is also available. Click on the multimedia viewer option. So at the bottom of your screen, next to participants and chat as options, there should be a little button that has 3 little dots. If you click on that, that should open up the multimedia viewer option, and there you should have some captioning available. So with that, we're going to actually get going here and actually get to the real substance of the program. This is the post-registration audit program, and we are very lucky today to have two excellent individuals. And actually, if you want to talk about folks who know more about the program than probably anybody else on earth, it's our two speakers today. We have Mantia Pressey. She is the Senior Supervisory Attorney in the USPTO's Office of Trademark Quality Review and Training, and the manager of the Post-Registration Audit Program. She first joined the USPTO in 1995 as an examining attorney, and she left for several years to work as an associate for a DC-based intellectual property law firm where her practice focused on trademark prosecution, client counseling, and providing advice in proceedings before the Trademark Trial and Appeal Board. And then, thankfully, she returned to us in 2004, and she has worked in the Office of the Deputy Commissioner for Examination Policy as a petitions attorney, a legal liaison to the Post-Registration Division, and a senior staff attorney in the Office of Trademark Quality Review and Training. Mantia received her law degree from Georgetown University Law Center and her undergraduate degree from the University of Virginia. Also with us today is Jordan Baker. Jordan joined the USPTO as an examining attorney in 2005 and is now an attorney in the USPTO's Trademark Innovation Lab Law Office. And since 2015, he has participated in a number of work projects in the post-registration area, including in his current role as lead attorney for Post-Registration Audit Program. As lead attorney, Jordan handles the day-to-day operations of the program, assisting with training and providing guidance to audit examiners, advising on IT matters related to the audit, and responding to questions from internal and external customers about the program. Jordan received his law degree from George Mason School of Law and his undergraduate degree from the University of Maryland. So that's our introductions. At this point, I'm going to hand it over to Mantia, and she is going to begin the presentation. Thanks so much.
Thank you, Jason, so much. Hello, everyone. It's great to be with you today. I'm going to go ahead and get started. Sorry about that. Alrighty. We are going to be talking about a number of topics today. Here they are. The first is we're going to start with a review of the significance of use in commerce. We'll discuss the history of the audit program. We'll then review audit procedures, which were revamped earlier in the year, and tell you the results to date. We'll also talk about responding to an audit using the T's response to office action form, which includes some audit-specific features. And we'll finish by sharing some suggestions on what you can and should be doing to prepare for a possible audit. Alrighty, so getting started with significance of use in commerce. As you know, generally use in commerce is required to register a trademark in the United States. Exceptions being Madrid registrations and marks registered under Section 44E based on a foreign registration. That means in applications listing only goods and services in use or for which there is a bona fide intent to use at the time of filing. And in post-registration maintenance declarations, any goods and services not in use and for which excusable non-use cannot be claimed should be deleted from the registration. You are likely aware that the Trademark Modernization Act includes new registration cancellation mechanisms, expungement and reexamination, which allow third parties and the USPTO director to challenge a registration based on evidence that the registration did not adhere or is not currently adhering to statutory use requirements. We are really excited to be adding these two new tools to help us in reducing clutter and to better protect the integrity of the trademark register. Accurately listing goods and services in use when filing any submissions before and after registration is critical to the accuracy of the trademark register. Inaccurate use claims can result in the cancellation or loss of a registration. They contribute to the deadwood on the trademark register. The claims can lead to unnecessary likelihood of confusion refusals based on IDs that don't reflect current use or even a bona fide intent to use a mark in commerce. And the claims diminish the register's utility to the public, making it really difficult to evaluate what marks are available for new business opportunities. And as you're aware, the Trademark Act imposes specific requirements for use of a mark to qualify as use in commerce in order to enjoy the great trademark benefits and protections that we have in the US. For goods, the marks must be placed on the goods, their containers or affixed tags or labels or associated displays, and the goods must be sold or transported in commerce. For services, the mark must be displayed in the sale or advertising of the services, and the services must be offered in commerce. And use cannot be mere token use. Instead, use must be as a source identifier and in the ordinary course of trade. Turning next to the history of the audit program. An impetus for the program was the N. Ray Bose Corporation decision in 2009, which prompted serious discussions within the USPTO about the landscape of the trademark register. You'll recall that in Bose, the CAFC held that it was insufficient for a party alleging fraud to prove only that another should have known of the falsity of its statement. The court stated that instead, proof of a false material representation made with the intent to deceive the USPTO was required. At a public roundtable about a year after Bose, the office considered the impact of that decision on the federal trademark registration system. Among the questions raised during the panel discussion was, might the higher threshold for proving fraud reduce the risks associated with filing inaccurate identifications of goods or services? To explore the answer to that question, 2 years later, in 2012, the office instituted a pilot program to audit registrations. 500 registrations were with 6-year Section 8 and 71 declarations of use were randomly selected, and we required additional proof of use. Those 500 registrations were comprised of a statistically significant sample of all 4 registration bases, so 1A, 44E, dual basis, and 66A, because we wanted a sense of whether any problems with overclaiming was tied to the registration basis. The final results of the pilot showed that in just over half of audited registrations, registration owners were unable to provide evidentiary support for the use claims in their original declarations, with 35% deleting goods and services and 16% failing to respond to office actions resulting in cancellation of the registration. In terms of results by registration basis, we saw deletion rates of over 50% in the Section 44E, 66A, and dual basis registrations. And when deletion rates are considered with the number of registrations that were canceled for failure to respond to an office action, which is reflected in that last column, across all registration bases, a substantial number of registrations were unable to verify the use claims in their declarations, with rates of 45% and higher across the board. So obviously, the final results of the pilot highlighted the need to do more for ongoing measures to encourage registration owners to file accurate declarations of use. So our next steps included public outreach. We held another roundtable, this one in December of 2014, contacted stakeholder groups directly, and we asked for written comments from interested parties. After considering all the feedback we received, a new rule was proposed and then implemented to make the audit program permanent. Effective March of 2017, the trademark rules of practice were amended to allow the USPTO to require additional support for use claims in Section 8 and 71 declarations, including information, declarations, and exhibits as may be reasonably necessary for the proper examination of an affidavit or declaration, and for the office to assess and promote the accuracy and integrity of the register. So with that, I'll pause and I'll turn it over to Jordan to talk about audit procedures.
Thank you, Montia. Good afternoon, everyone. Great to be here. Happy to talk to y'all. When the program was launched, so the audit program became a permanent program on November 1st, 2017. To be eligible for an audit, the registration must have at least 4 or more goods or services. If it's a single class registration, if it's a multi-class registration, there has to be at least 2 classes with 2 or more goods or services. Of course, a Section 8 or 71 has to be filed. Without a Section 8 or 71, can't have any immediate eligibility. Besides 8 or 71, we also look at combined filings, your Section 8 and 15, your Section 8 and 9, and your 71 and 15. If the 8 or 71 has a non-use claim, then it's not going to be eligible for the audit. And we use a software tool to determine eligibility. We have a software program that creates a randomized list, and that randomized list is of eligible files. And audits are performed by, we call it audit examiners. It's a mix of examining attorneys as well as program analysts who have expertise in the post-registration area. So what is proof of use? Proof of use is how you show that your mark is in use in commerce, and essentially it aligns with our specimen practice, but it also is elevated, particularly with goods. For goods, if the mark is actually on the physical goods, that is proof of use, but it also can be shown through tags or labels. So a photograph of the mark on a tag or label, if it's fixed to the goods, is proof of use, but if it's not affixed to the goods, it can work as well if it includes the generic name of the goods. And also we want to see on that tag or label other product information. So that might be a UPC code that would, in a place where it would typically be, it could be product size information, packaging information, other matter that goes on a label or tag that would show, in fact, use in commerce, proof of use in a commercial setting, and not just the mark without any other context. Proof of use for goods can also be at a point of sale display in terms of a web store. And so a screenshot of an online store where the goods are being sold and when they can be added to cart or they can be ordered or purchased and there's clear ordering or purchasing information is acceptable. But all screenshots have to have the required URL of the website as well as the date accessed or printed. We'll also take packaging. And for packaging, it's helpful if the packaging is transparent because we need to know exactly what is in that packaging. The whole point is it's proof of use for specifically requested goods. And if we cannot identify what's in the packaging, we have to look for other sources to confirm, and that may in fact require a request for additional information. This often comes up in the situation of goods that are located in a opaque box or container. We don't know what's inside. So photographs that are both show the packaging with the mark on it, but also what's inside the container is very helpful. Proof of use for services is the same as it is for the specimen practice. There's no difference in what can be submitted for services. So if you're in your advertising, marketing context, brochures or flyers that show use of the mark, but it has to have a direct association with the services. The whole point is that when we ask proof of use for very specific services, the mark has to function for those services. Could be photographs of a mark on a retail store or restaurant signage. But similarly to the container issue, when you have a mark on signage, we need to know what goes on in the building that the signage is being used for. Sometimes this is very obvious. If it's a restaurant and there's maybe hamburger artwork on the windows, perhaps, or on the sign, that makes a lot of sense. But if it's sort of an industrial or commercial building where there's no obvious indicator of what kind of custom manufacturing might be going on inside that building, again, context will always be needed to support what you're submitting as proof of use. One example for services that's common is a mark on service vehicles. So if it's a pest company services and the mark is clearly on a truck that's used and it references some kind of pest or let's say insect or bug example on there, that's a common way of showing proof of use when it's printed on the side of the vehicle. And screenshots, just like with goods, website screenshots will still require the URL and the date accessed or printed. I will now turn this back to Montia, who's going to talk about our new deletion fee and the related deficiency surcharge.
Thank you, Jordan. So Jordan is going to be back to talk about the audit procedures in just a moment. But I wanted to highlight 3 changes in post-registration examination policy that became effective on January 2nd of this year, which caused us to modify some of the procedures in the audit program some. These new policies, though, apply across all post-registration examination. The first change is a new fee of $250 per class that's incurred when goods, services, or classes are deleted during the pendency of a Section 8 or 71 declaration. The second change is that in some cases, a one-time $100 deficiency surcharge must be paid along with that deletion fee. Both the deletion fee and the deficiency surcharge are tied to the statutory requirement that declarations under Section 8 and 71 identify the goods and services in the registration with which the mark is in use in commerce. Deleting goods or services from a declaration is an effort to correct a deficiency or an inaccuracy in that original listing of goods or services in the declaration. Okay. To encourage registration owners not to wait until after they file their Section 8 or 71 declaration to delete goods and services when that $250 deletion fee would be due, we introduced a third change, a new zero fee option for certain Section 7 requests. This option is only available when the Section 7 request is submitted before the Section 8 or 71 declaration is filed or after it's been accepted, and the Section 7 filing only requests the deletion of goods, services, or classes. So for example, if the Section 7 request also includes a change in the owner name or there's an amendment to the registered mark, the normal fee of $100 for the Section 7 request would be incurred. As I mentioned, deleting goods and services during the pendency of a Section 8 or 71 declaration is an indication that the listing of goods and services in the declaration is deficient, because it didn't satisfy that statutory requirement, again, to list goods and services in use in commerce. Other deficiencies in a declaration include submitting an insufficient filing fee, filing an unacceptable specimen, and identifying the wrong party as the current owner of the registration. In line with how other deficiencies are treated, a deficiency in the listing of goods and services in a Section 8 or 71 declaration can be corrected, but a one-time $100 deficiency surcharge may be required. This is determined by the date the original declaration was filed and the date of the response correcting the deficiency in the declaration. So for example, if you were to file your Section 8 declaration right after the 5th year following the date of registration, which would be period 1, and in response to an audit office action, you delete goods and services, and that response is filed before the 6th year, which would also be period 1, you would owe the $250 deletion fee, but not the deficiency surcharge. In contrast, if you didn't file that response deleting goods and services until after the 6th year, when you would be in period 2, you would owe both the $250 deletion fee and the $100 deficiency surcharge. So to sum up, A fee of $250 per class is required each time a response is submitted deleting goods, services, or classes during the pendency of a Section 8 or 71 declaration. But the $100 deficiency surcharge, which is only paid once, regardless of the number of deficiencies in a declaration, is only required when you're responding by correcting a deficiency in a filing period that's different from the filing period of your original Section 8 or 71 declaration. And now back to Jordan for more on audit procedures.
Thank you, Mantia. All right, let's get into the inner workings of a proof of use audit by first addressing your initial office action that you're going to receive. That initial office action is going to request proof of use for 2 goods or services if it's a single class registration, and if it's a multi-class registration, it may be 2 goods or services per multi-class. It could be 1 in a multi-class where there's only 2 goods or services and there's no proof of use for one of those items, or it may even be proof of use for a class that has just a single item, but the specimen submitted is unacceptable. And that might be the case, unacceptable as proof of use. And so that might be the case of a tag for clothing items that just has the mark, but nothing else on it, and it's not attached or anything. So that's the immediate proof of use portion of your initial office action. But there's more. We'll also address any underlying issues in the Section 8 or 71 declaration. And how does the audit, how does that initial office action pick what kinds of goods or services are going to be requested for proof of use? Well, first, it's the audit examiner's discretion on what to choose for proof of use. And that is after review of the 8 or 71 in terms of the specimens to see what the specimens cover for proof of use and to ensure that we don't ask for proof of use for things already submitted. The audit examiner is going to look mostly for disparate goods or services if possible. But what I mean by that is in a typical example, you have a registration that has, it's in class 9, that has numerous items of downloadable software. But the registration also has sunglasses and fire extinguishing apparatus. These specimens that were submitted show clearly use of the mark on variety of software goods, but there's no reference at all in the record in the 8 or 71 to the sunglasses or fire extinguishing apparatus. Pretty good chance that when the audit examiner is reviewing that file, they're going to seize on those disparate goods that have not been already been, there's no proof of use in the record. And the audit examiner is going to do their best to make sure they select clearly from the registration what it is exactly that they're asking for. That can sometimes be difficult given sometimes registration ID construction, but we try to make it very clear what it is that we want to see in a response. All right, so your initial office action, as I noted, will reference any inquiries or deficiencies with the maintenance filing, and then it will include a whole series of advisories. The first advisory is that if you cannot provide proof of use for what is requested, you must delete the audited goods or services if it's not available. Not only that, you should also delete any goods or services that are also in the registration that does not have proof of use available, even if we didn't ask for them. So this is a time where you're going to really go over that portfolio again of what is in this registration and determine at that point, if you can't show proof of use for it, it should be removed from the registration. Other advisory is going to be that pay the deletion fee, as Mantia has talked to us already now. If you have to delete items from that registration, you're going to have to pay that $250 per class, as well as possibly the deficiency surcharge. So the advisory in the first office action about potentially needing to pay the deficiency surcharge based on the timelines that we've discussed. The initial office action also warns that if you don't satisfy the audit in your response, it's a possibility that you will get a second office action, which will escalate the audit to a request for proof of use for everything remaining without proof of use in the audited class. Finally, you are given response guidelines, and that if you do not respond, the entire registration is canceled. There is no partial aspect to an audit an audit review. Essentially, if you do not respond, even if several classes were not subject to audit, and in the initial office action will let you know what classes are being requested and which ones, if it's not mentioned, likely it's not under audit. But if you don't respond, the whole thing gets canceled. So keep that in mind. Going back to the deadlines, your response deadline is going to be 6 months to respond, or to the end of the relevant statutory filing period, whatever is longer. So if you file early in your renewal period, let's say in the very beginning of the 5th year, and you get an office action fairly quick, you might have a response period quite a bit longer than 6 months, maybe 10, 11 months, won't be more than a year, but you have quite a long horizon to respond. So now that you've gotten your office action, what is your strategy to respond? Well, we encourage a strategy to complete an entire audit in a single response. This is perhaps to keep costs down or just a matter of efficiency, but you can resolve everything you need, hopefully, in an audit in one single response back. If you have proof of use for what we've asked for, that's great. We will eagerly await that proof of use in a response and review it, but help us out by labeling, describing exactly what it is you're submitting. It's not always obvious what we're looking at. Sometimes some goods are clearly very obvious, but more often than not, especially with commercial or industrial items, let us know clearly in the form or on your attachments, somewhere this image described is this goods. Phrases or sentences like photo of mark on goods is not super helpful to us when we're looking at non-ordinary or just not obvious kind of items. I'll give you an examples. Well, actually, I'll talk about this in a moment as well. So in your response, as a matter of strategy, if you have determined that other items in your registration are not available for proof of use, you should delete those items as well as pay the fee. And again, also pay that deficiency surcharge if it is due, if deletions are being made, or there's any other item deficiency in the first office action, perhaps responding to a specimen refusal. If you do have to provide additional proof of use for the remaining items in a registration, make sure you label those as well. There's lots of situations where you may have numerous strings of goods or services, and the more you provide to us on what exactly we're looking at, and so we can match up what's in the registration to what's in your response, the better. Provide charts, lists, tables, exhibits that describe proof of use in large documents. These files can become voluminous. If you have a long list of goods or services, it's very helpful if we have some kind of index to rely on. Exhibit A goes to shirts and Exhibit B goes to pants. I mean, those are obvious goods, but obviously you can imagine in your head if you're dealing with paper shredding machines or lawn equipment in a commercial setting or whatnot. The more you provide to us, the more it's going to help review your response. Also, things like instruction manuals that might have a mark in it used in an acceptable manner, but that manual might be 200 pages long. Let us know where in that manual the mark is. If we're starting to fish around for it, you run the risk that we might just miss it, which of course we don't want to do, but it can happen. So let us know on page 83 of whatever manual the mark is there and it describes whatever it's supposed to describe in the manual. Don't resubmit evidence already in PTO records, US PTO records from past filings. Just creates a possible flag of, is this proof of current use? I'm sure you can think of examples where a picture of goods from prior filing might be the identical picture of the good that exists now. But the point is that because that same image was submitted years ago, well, is it really showing use right now? It may, but it also may not. And you also run the risk of prior filings where there's date stamps on those images. You don't want to submit a date stamp from prior years ago when you're saying it's current use right now. Well, if we can't figure out what is being submitted, you may end up getting another office action with a request for information. And that request for information might ask for additional photographs or documentation supporting proof of use. This comes up often with items where photographs are zoomed in and they show the mark physically on goods, but there's no broader view of what the goods are. And it could be a variety of items. So we might, so we encourage multiple images sometimes. If let's say an example of a label sewn in on a waistband of clothing. Well, that waistband could show pants, it could show shorts, it could show skirts, capris, a whole variety. So submit maybe a close-up image and a zoomed-out image. If you run the risk of getting an RFI, a request for information, it delays the process, but you also run the risk of getting a second office action if we just don't think proof of use is there, and that, of course, escalates the audit to another level. So once your response is submitted, if proof of use is provided, we will issue the acceptance. If proof of use is not provided for what we asked for, but deletions have been made and proof of use exists for everything else, we will issue the acceptance as long as all fees are paid. However, if the response does not resolve all issues, a second office action will issue. And your second office action is going to ask for proof of use for all the remaining goods or services in the audited classes without acceptable proof of use, and it'll include a listing of any outstanding fees. Your second office action has multiple component parts. The first part of a second office action will give you your status of what any issues that have been resolved, and then what is outstanding. And it will indicate if you have made any deletion requests in your first response. It will note that deletions for the requested goods or services have been entered. The second office action will have a list of all of the goods or services that do have proof of use in the audited classes. And then it will also include a list of all the goods or services that do not have proof of use in the audited classes and which must be shown in a response. If any proof of use submitted in the first response was rejected, that second office action will include an explanation of why the proof of use was unacceptable. And then the second office action will also go through all the fee issues and indicate what additional fees are outstanding and what may be due. A response is submitted to the second office action. We do the same analysis we do after a first office action. Are all of the underlying issues in the maintenance filing resolved? Has proof of use been shown for all of the goods or services without proof of use? And if so, and all fees are paid, we will issue the notice of acceptance. And if not, well, then we'll go to the next step, which is a third office action. But that second action, that second office action, when it gets issued, the response is similar to the first response deadlines. You will have 6 months to respond to a second office action or to the end of the statutory filing period if that is longer. Now, before we talk about the third office action, let's go pivot right back to deletion fees. So it kind of keeps just popping up here. Your deletion fees are successive. So each time that a filing is made once an audit has started and deletions are made, the fee must be paid again. And the fee is paid if it's just a couple goods or services or an entire class. An example of how the fees are successive. So in a response to the initial office action, ABC Company deletes goods from 3 classes. So that would be fees of $750 in deletions. In response to that, but the audit was not satisfied. So a second office action goes out, and in response to the second office action, ABC Company deletes goods from 2 of the same classes. So at that point, they've now incurred the equivalent of 5 times of class deletion, so $1,250 of deletion fees. You can see how these fees escalate if a strategy of not resolving everything in a first action is not taken. So let's go back to audit procedure with the office actions. We're now at the point where you get to a third office action. Your third office action, and this is where practice has changed a lot since the fee rule came into effect. We used to have the ability of a partial third office action, which would set out items which don't have proof of use. And if you did not respond, you didn't do anything, then the office would delete those goods or services. But that does not exist anymore. The new procedures after the fee rule makes the third office action into a notice that will list what goods or services do not have proof of use. It will provide arguments for any rejected proof of use submitted with the second office action that was not accepted. And then it will give you revised response options. So this is the new procedure. Your revised response options are 2 or 3 ways of handling it based on where you are in time. The first is that you can file a petition to the director, and that's if you disagree with the audit examiner's findings, or if you wish to have new proof of use or additional proof of use submitted for review. So you will have 6 months to respond, and you can file a petition to the director for those issues. In the alternative, you can file a post-registration response to office action through the T system and request the deletion of any goods or services without proof of use. That is the only kind of response that we will accept of a post-registration response form at this stage. Any substantive argument or substantive response or additional evidence provided that way will not be reviewed. We will send you an office action that acknowledges that response, but that it's not being reviewed and that the original timelines in a third office action are maintained. If there is time left, however, before the end of the grace period, you can file a new Section 8 or 71. But you will pay all the new fees for that, and any deletions made to the registration up to that point will remain. Not only that, you don't escape the audit. So you can still do that. You still have the benefit of filing before the end of the grace period, but it does come with its own set of challenges. As I noted, response deadlines for third office actions are different than the first and second office action. No later than 6 months from the issue date of the office action, both for filing a petition or for requesting that the goods or services are deleted with payment of all fees in that response to office action. If no response comes in at all, the entire registration will be canceled. All right, so taking a little break from procedure, let's talk some results. This chart here shows results to date of the program. This is through April 30th, 2021. And we've issued just under 15,000 first actions by the end of April, and 11,820 responses have come in. In that disparity between issued and responses, that has to be that's due partially to cancellations. So up until that point, we had roughly 1,500 cancellations, and the remaining number is just pending files where office actions have gone out, but responses haven't come in yet. Of responses received, 6,087 registrations have deleted goods, services, or classes, and that's 51%. 51%, so more than half of all registrations who have submitted a response have deleted at least something in that response. When you factor in the cancellation rate, that goes to 57%. Looking at the last two lines, percent represented by U.S. attorney, that is at 82% have attorneys on these files, and that is up from 79% when this program started. It could be a variety of factors, but one of them likely is that ever since the U.S. counsel rule came into effect, requiring U.S. counsel for foreign domiciled entities, there's been an uptick of number of audits for this counsel representation. Some additional statistics of the 1,500 or so that this is from June 1st. This is an updated, hot off the press stat. We had 1,574 cancellations as of June 1st, but of those, 1,360 were no response at all to the initial office action. So most of our cancellations are, by far most, are from files where they got the first action, audit letter, and just no response was submitted. We issue about 33% of all audits go to a second office action, meaning that they didn't satisfy the audit in response to in their first office action response, and about only 5% make it to a third office action. And looking at the results to date by filing basis, you can see under Section 1A, it's 47% have had to make deletions in their responses. But then you look at the three foreign-based 44E, 66A, and 1A and 44E, and you can see it's significantly higher. And this has been consistent throughout the life of the audit program. We have been in that mid 60% range for all three of those bases. And so we will look to see how the new fee rule alters these statistics as that keeps getting diffused as our program goes forward. And if you were just curious, in a breakdown of audit percentage by basis, 78% of all audits are 1A basis, and the next highest is 15%, and that's the 66A basis. The other 44E and 1A and 44E are a bit more marginal statistically. This slide shows our monthly deletion percentage. This is an interesting insight. It looks at of the responses reviewed in a month-long period on a registration basis, how many of those registrations with the response getting reviewed had a deletion. And this kind of fluctuates a bit up and down per month. There's an asterisk for April 2021 because we were on hold for several months while we implemented the fee rule. But it's never since this slide goes back 2 years, but since the program's inception, we've never had less than 40% a month, and we've never been higher than 60%. And so this is also something that we're going to chart and look to see going forward with the fee rule, and whether we can start seeing a trend of declining monthly deletion percentage here. We hope that we'll see that with the new fee rule. Responding to an audit, this is a TEAS electronic system centric couple of slides here. We wanted to highlight a few changes that were made to the TEAS system late in 2020 that gave specific portions of the forms to respond to an audit. Not only that, because there are so many deletions, improvements were made to the modification of an identification of goods or services field to work together with the audit portions. And so looking at the slide, might be a little hard to read, so I apologize. And when you hit the slide deck, it'll be a little more clear, but we hope you can do the best here with this. Number 2 on the wizard asks you need to do any of the following, and the middle bullet point there is to modify the identification of goods or services. You're going to want to click yes to number 2 if you have to enter any kind of deletions in your response. And number 3 immediately below is, do you need to respond to a proof of use audit? So you want to make sure 2 and 3 are yes if you're making any deletions. If you're not making any deletions and just submitting proof of use, then only 3 has to be yes, unless another issue has to get addressed from the other options. And what this looks like is when you go to make your goods and services changes, there's a track changes feature. And in this gray box at the very bottom, it says modify identification. And so your ID will populate in there, and you will highlight with your mouse or highlighting device any of the text that you wish to delete. And if you hit the delete button, it will then strike through that wording. And so once you've entered all of that and you hit continue in the form, it'll reflect those changes elsewhere in the TEAS form. And by elsewhere, I mean here in the proof of use portion. This is only a portion of the proof of use section of the TEAS form. But if you look at the current listing of goods and services for class, in this case, this is a class 25, it will reflect the modified ID from the deletions. And this is very helpful because if you are deleting all sorts of items and you have to provide proof of use, you really only want to look at what it is that you're providing proof of use when you're adding your images to the form here. So your modified ID will show up in this table. And if you select the first radio button, proof of use provided below for this class, this will then refresh and it will show a series of boxes where you can attach your proof of use and describe it. I wanted to highlight 2 portions of the form. First, it says audited goods or services with a red asterisk. That's a required box. So that's where you would type in proof of use submitted for, and you would indicate the name of the goods or services that we asked for. And then immediately below, it says describe the attached evidence for this item. This goes back to what I referenced earlier, where a phrase like image of mark on goods is not super helpful. So you want to take this time to use this required box to indicate, mark on sweatshirt goods, or you want to be as precise as possible. And if it's more complicated kind of proof of use being offered, take the time to use that box to describe exactly what it is you're submitting. The more context, the better. And then at the very bottom of this image is a box that says click here to attach a proof of use. That just does the uploader. You have a lot of flexibility in these forms to put all the data that we need in various places. So don't be shy. Get all of it into the form when you can, and give us as much as we can to look at. Lastly, this slide shows the fees as the topic du jour. The last question the wizard is going to be, do you have to submit any fees? And as long as you submit yes to that, it will trigger the fee menu. And this slide shows at the very bottom here in this red box, the last item is the deletion fee. And on the right, you'll see a multiplier. So you can use that multiplier to get to the right amount that you have to submit for your fees. As we talked about with successive fees, you might need to do a little bit of math to calculate it, but you can do that all here. And then immediately above that is the deficiency fee. So they're paired together, and that's where you can handle selecting all the right fees and take care of the payment at the appropriate payment screen. And with that, I will turn this back over to Montia, who's going to bring us home in how to prepare for an audit.
Thank you, Jordan. Okay, waiting on the slides over. All righty. So as Jordan mentioned a little earlier, we've audited almost 15,000 registrations in the permanent program since 2017. And we plan to audit at least 5,000 registrations a year going forward. So there's a very good chance that you'll receive an audit office action at some point. From the stats that were just shared, it's really clear that there's still work to be done to prompt the changes in filing behavior that we'd like to see to improve the register integrity issues that we've seen since we started the program way back in 2012 as a pilot. We do hope, as Jordan mentioned, that the recent changes like the deletion fee, as well as the upcoming policy changes, will help to speed along that improvement. So we'll end with a few reminders about the legal obligations for declarations and all submissions to the office, and provide some tips for preparing for an audit. So first off, another reminder here that when about the importance of accurate listing goods and services that are in use in commerce in your Section 8 and 71 declaration when you file them with our office. The person signing is swearing that the mark is in use with the goods and services listed in the declaration, and that the specimens submitted show current use in commerce with those goods and services. And whoever signs or files that declaration is certifying that, to the best of their knowledge, information, and belief, formed after an inquiry reasonable under the circumstances, the contentions have evidentiary support. Two things to highlight there: the requirements for reasonable inquiry and for evidentiary support. We'll return to both of them in a moment. Note that criminal penalties are available for knowingly and willfully making any false statements. In fact, all submissions to our office must comply with the requirement for reasonable inquiry and evidentiary support where appropriate. Submissions must not be presented for any improper purpose, and they must comply with existing laws. Sanctions are available for non-compliance. Returning to the requirement for a reasonable inquiry, what would be considered reasonable is really highly fact-specific. So, for example, in cases where an attorney submits a declaration that's signed by a client, the question of reasonableness of that inquiry may depend on the client's sophistication and experience with trademark law. Attorneys should ensure, though, that their clients understand the requirement for use in commerce and that their clients have taken the appropriate steps to confirm use. An attorney generally may rely on information that's provided by a properly educated client unless the attorney has reason to believe that the information is inaccurate or incomplete. Attorneys should review all relevant information and discuss with the client any documents or other information that appears on its face to be questionable. Returning to the requirement for evidentiary support, consider creating a checklist by listing each good and service in the ID on a separate line by cutting and pasting that information from TSDR. And when use of a mark is confirmed, take photographs of the goods, print supporting web pages and URLs with the date of printing, and keep any other supporting documentation for your records so that you do have that evidentiary support. If use of commerce can't be confirmed, as soon as you can and before you file that Section 8 or 71 declaration, take advantage of that new zero fee option for filing a Section 7 request and delete those goods, services, and classes from your registration. Proactively ensuring that IDs and registrations accurately reflect goods and services used in commerce, and even before you approach your statutory filing deadlines, will be even more important once our reexamination expungement mechanisms are available. So if you know that use of a mark with any goods and services has been permanently discontinued or never started, delete them or you should consider deleting them from your registration as soon as possible. You do have the option still to delete the goods and services within your Section 8 or 71 declaration itself without paying the fee. But again, we really want to encourage you to use that free Section 7 option and delete them as soon as you are aware that those items are not in use and that there's no excusable non-use claim. And finally, we'd like to encourage you to take a look at our updated audit webpage for even more information about audit procedures. We recently added, for example, proof of use examples to the page to give you a sense of what would be acceptable to prove use. We hope that the information provided today and available on our website will help you to complete that audit with one response. So I think that's the end of our presentation. And I know we're going to take some questions, and I believe that Jason Lott is going to be returning.
Yes, I am returning. Thank you very much, Montia. Thank you very much, Jordan. All right, folks, we are going to now shift into the Q&A portion. We know that a lot of you have been sending in some questions. Thank you very much for sending those in. Some great questions coming in. If you have a question, haven't asked it yet, please feel free to send to tm_webinar@uspto.gov. Please note we're going to do our best to answer as many of them as we possibly can in the time remaining, but also be aware, and I haven't necessarily seen any of these yet, but please try and avoid very specific questions because we cannot give legal advice, so we can't necessarily give an answer that is going to say, yes, this is totally fine. So you know the deal. So feel free to send those in. I haven't seen any yet, but if you have any TMA questions, please hold off on sending those in because really we're just focusing on post-registration audit stuff today. We do have a roundtable coming up on June 14th. I'm going to show you the webpage for that before we close out today. But just want to keep that in mind. Hold on to those TMA questions because we are going to answer them, just not today. So our first question is going to be to Jordan. Jordan, go right ahead.
All right, we'll each read the question and then answer. So the first question is, are all registrations meeting the specific criteria of the Section 8 or 71 selected for audit? And if not, what percentage of qualifying registrations are audited? Good question, and no, because that would be far more audits than we've been able to conduct per year. So our goal has been 5,000 audits. I can in the last several years, our total post-registration number for Section 8 and 71 is somewhere around 180,000, I believe, within range of a couple higher or lower. So we're a much smaller percentage. And then the software gives us a list of usually a couple thousand or so eligible files per bi-week. We go by bi-week. But then we have to go through them, and many files are not eligible because, thankfully, we've gotten too many good specimens once they come in. So you may, as the audit program has gone on for several years now, people are aware of it, and they have improved the quality and of their Section 8 and 71s and the quantity of how many specimens we get. And of course, if there's nothing for us to ask proof of use for, it's not eligible for audit. So, so I don't have a percentage number for you there, but it's definitely not anywhere close to everything that's eligible. And I don't think we've really been able to put a number on the qualifying part because we have to go through and make sure we don't select things where there's nothing to ask for. But the two numbers to keep in mind are there's about 180,000 Section 8 and 71s a year filing, and our goal is to do 5,000 audits.
Okay, me next. Okay, so my question is there any way to avoid both the $250 deletion fee and the $100 deficiency surcharge for deleting goods and services from a registration? And the answer is yes. And the answer is the rest of the question, which is, for example, can we delete goods, services from a registration before filing the Section 8 or 71 declaration or concurrently with the maintenance filing and not incur any fees? So yes, that's absolutely the way you should do it. Again, we encourage you to file any deletions that if you know that you've stopped using a mark, the goods with any particular or services with the mark, delete the goods and services as quickly as you can, as early in the process as you can. And then you will not incur that deletion fee or the deficiency surcharge for deleting at that time.
Thank you, Montia. Next question is, can a registrant be sent an office action based on Section 8 deficiencies and also be sent a separate office action based on an audit for the same Section 8? That's not supposed to happen. It shouldn't. They should be everything should be addressed together. I like to say that the audit kind of layers on and over regular post-registration review. The audit examiner is always going to review the Section 8 or 71, just like a post-registration specialist would review. And then as long as it's an eligible file, they will add the audit on top of that. So there shouldn't be any separate office actions. There's no office action for a Section 8 coming out of post-registration that has a deficiency that gets handed off to the audits. There's no connection between the groups that way. So hopefully that answers that question.
Thank you, Jordan. Okay, next one. Do deletion fees also apply to goods that were actually in use in the past, such as CDs, but are no longer used by the registrant, i.e. there was no misrepresentation, but the goods services were phased out since registration? So the answer is yes. What you should be doing is, before you file your Section 8 or 71 declaration, you should be doing an inventory like we described and looking for evidence or proof that the mark is in use with, for example, the CDs. Before you file, you should delete those CDs from that Section 8 if you can't confirm use. So if you don't delete them and you file that Section 8 and then we select the registration for audit and we ask for the CDs, then yes, the deletion fee would apply, because you would need to delete those items in order to move forward and have your Section 8 declaration accepted eventually.
All right. Can one piece of proof of use show use for more than one item in the identification of goods services? For example, an ID could include chocolate confectionery containing pralines and chocolate confectionery having a praline flavor. So yes, it certainly can. This happens a lot in particular classes that with the ID construction, there's often overlap. One example might be jewelry. And rings are separate items listed in an ID. And if we ask for rings, that would be also able to cover jewelry as well. We do not need redundant submissions of images to cover items that cover both, but doesn't hurt if you label everything right. As to the specificity of the chocolate confectionery question raised, what I like to say is that we always look at the common commercial understanding of what a term is that's in an ID. So we look to see how if you did a search for that term, and we look to see how it's sold in the marketplace, how is it referred to? Because we also have a lot of redundancy in IDs, where certain items, a singular item may be described in 4 or 5 different ways. We will take a single piece of proof of use if it does cover all 5 of those ways, as long as it's not some kind of specific or technical nuance where it wouldn't really be appropriate. For some reason, hot chocolate is always one of those items it's a beverage, but it's got 4 or 5 different listings for the same item. It kind of comes up a lot. And we really try to go out of our way in an audit to not ask for the same thing twice. Because that sort of doesn't really go to the purpose of asking proof of use. So we try to steer away from asking from 2 different ways of saying for the same item.
Thank you, Jordan. So the next one is, if you are required to pay a deficiency fee, will you be informed ahead of time, or must you anticipate that when submitting? So whether or not the deficiency fee is owed, in some cases, will depend on, for instance, the issue and the timing when your office action first goes out. So for instance, if by the time the office action goes out, if you file in period 1 and you file your original Section 8 in period 1, and that office action is going out in period 2, then we'll tell you that, for instance, if you have a specimen issue, you're going to need to pay that deficiency surcharge. But in other cases, for example, if you file really early on in period 1, where there's still time left when you could, in theory, respond within that same period 1, we don't know whether or not you will owe a deficiency surcharge. It'll depend on the time period when you actually respond. But that will be explained, and it'll say, hey, you need to pay a deficiency surcharge if you file your response after this date. But in other cases, if we're already in period 2, for example, when we issue that office action, then yes, we'll say, oh, by the way, you owe a deficiency surcharge, your specimen is bad, and you need to respond with an acceptable specimen and the deficiency surcharge.
All right, we have a fact pattern here. This is actually a very common fact pattern question, so I'm really glad this is asked. And I'll note also that the audit program wasn't always entirely 100% consistent on how we handled this in the very early days. So I'm glad this question was asked. So 2 classes are audited, and a response submits proof of use for items. In one class, the proof of use is accepted, and in the other class, the proof of use is not accepted. Will the second office action require proof of use for all items remaining in the entire registration, or just remaining in the class where the proof of use was not accepted? And so the audits are on a class-by-class basis. So in this case, the second office action will only escalate to ask for proof of use in the audited class where the audit was not satisfied. So only one class here will get a requirement to provide proof of use for everything that's not provided proof of use yet in that class. The first class, it will note that the audit has been resolved for class 1 and that this second office action letter is only applicable to class 2.
Okay, thank you. So the next question is, can you delete a service or good after you file a Section 8 that was accepted and still avoid a fee? In other words, you discover a service that is no longer offered, but was soon after a Section 8 was accepted. The answer is yes. You would not have to pay that deletion fee if the Section 8 has been accepted. When you then file your Section 7 and you wouldn't have to pay the Section 7 filing fee at that point either. Once that Section 8 is accepted, yes, you can go ahead and delete via Section 7 without paying the deletion fee.
Once a company has been audited and has had to delete goods or services, will that make them more vulnerable to being audited continuously going forward? Present practice is that we do not have repeat audits. The program is still fairly new, so we've really just sort of barely dipped our toes into this coming up. But as of now, if a registration has been audited once, we are not treating it as eligible for an audit when it files its next maintenance filing.
Okay, the next one. Do I always need to pay the deficiency surcharge when paying the deletion fee? So again, it's going to vary. It's going to depend on when you respond and when you filed your original Section 8 or 71 declaration. If you're deleting and you're responding with the deletion fee within the same period that your Section 8 or 71 declaration was filed, then you wouldn't owe us that deficiency surcharge. But if by the time you respond, for instance, that 6-year period has ended and you're now in the 6-month grace period and you're deleting, you would need both the deletion fee as well as the deficiency surcharge.
If a registrant can provide the requested proof of use in response to the third office action, is a petition required? Under the revised rules after the fee change, yes, a petition is required to submit additional proof of use evidence that has not previously been submitted. And that includes paying of the petition fee.
Waiting on the next question. Okay, who is conducting the review for the audit? And are they trained to fully understand the specimen proof of use rule? Yes. First of all, I'll answer the second question first. Yes, they are absolutely trained to understand specimen the proof of use. The staff includes examining attorneys on work projects, as well as program analysts who are really experienced, have an expert level knowledge base when it comes to post-registration examination, as well as specimens. And Jordan and I actually both do the training for the audit team examiners. So absolutely, they are well trained on both specimens as well as the proof of use.
Question is, do you have data on how successful a response to an audit is based on whether someone has representation or not? Okay, there's a couple of ambiguities here on what successful means. in terms of, does that mean getting to a notice of acceptance? No deletions or not? 2 years ago, we did a fairly deep dive into a sample of more than 2,000 registrations, where we looked at the breakdown between audit files with representation or pro se. We actually found that there were more deletions made in the representation registrations. So the pro se respondents had made less deletions and were able to satisfy their audits without making any deletions at a slightly higher percentage rate than those with counsel. I do not have the exact number in my head right now because it's been a couple years. I will note we are actually this summer going to be doing an additional data analysis on a fairly large sample of registrations. But I do believe it was pretty close, the split between the two. It's hard to say to satisfy, successfully completing an audit can have lots of different meanings. So I don't think I want to get into that. I mean, you can get your notice of acceptance, delete 1 or 2 items, and that might be successful if you have several hundred items. It's all based on context. But it's not intuitive to think that just because someone is pro se, that automatically they are going to do worse in an audit than someone that has counsel. And I think our data backs that up quite a bit.
Okay, thank you, Jordan. Next one is, does the USPTO plan on increasing the number of audits conducted in the coming years? I will say currently for the indefinite future, I would say, Jordan, I've not heard of any plans to increase. We are going to be, for now, continuing with that 5,000 case, a year goal. Certainly we would love to, if staffing and permitted, that would certainly be something I think we would want to consider. But for now, we are just doing the 5,000 per year as our goal for the program. And of course, if examiners get really ambitious and want to help us to do more, that's certainly, we love and appreciate the work that our examiners do. But the official goal for the office is 5,000 per year.
I'll just tack on to that. When the rule was written, I believe it was sort of figured at 10% of post-registration filings, if I recall it right. Well, that'd be 18,000 or so roughly. So we're not close to that. So there is room for flexibility, but
yeah, and actually, I don't think the rule actually caps it at anything. It says to start with 10%. Yep. So it's dream big. Why not? but yeah, it's 5,000.
So question is, can you speak a little more as to the software and process for identifying registrations that are chosen for audit? Are they truly random, or does the software select a certain number of registrations under each basis? It is as random as one believes in randomness as a matter of software programming. There is no program bias to target certain bases. We don't do that. The software, I can let you know, updates itself every bi-week. We get a table of all the eligible files run in the prior bi-week, and that software runs on a basis of parsing IDs through semicolons and commas. And then when an audit examiner logs into the software, they get a numerical list, and they are instructed to go through that list one by one. And it's just presented in a randomized order. Every time you refresh on that software, it rejumbles the table. That's worked for us for a few years now. There's no other anything else to the software in terms of basis or targeting really long IDs or nothing like that. It's simply a minimum criteria, looking at a minimum number of commas and semicolons. So we just have a basis to start through, and we just go one by one down and look to see it. And if it's got a non-use claim, it gets bounced out. And if there's proof of use for enough items to not pick anything to audit, it just gets bounced out as well.
Okay, thank you, Jordan. Another 2-part question. If during an audit you find that a product such as software on CDs in Class 9 has evolved into non-downloadable software in Class 42, can that be revised instead of deleted during an audit? Is the evolving technology amendment still available? So I'll answer the second part of that first, which is yes, technology evolution petitions are available to amend IDs. They are, again, there's a petition that must be filed in order to avail yourself of that request to amend. As far as, and Jordan, I'm going to punt to you on this, are you aware of us ever considering in the midst of an audit, a request to basically, I guess it would be, we need to suspend the audit in order to consider the petition seeking to amend the ID. I'm not aware of us ever doing that, but.
No, I don't think we've had any kind of suspension of
Yeah.
that request.
But again, if you're proactively reviewing your ID before you file your Section 8 or 71 declaration, hopefully you're realizing that your class, your CDs are now a class 42 item. And so again, that's another really good and important reason to do your due diligence early to see what's in use and what's not in use, and take care of that Tech Evo petition in advance of filing your Section 8 or 71 declaration.
Yeah, we have had several Tech Evo petitions for audited files, but nothing since the fee rule has come out. So we haven't seen how that works together, if at all, yet. Couple of questions here. One is, are foreign registrants selected for an audit more than domestic registrants? There's, as we've noted, there's no specific targeting by filing basis. So the only statistic I have on that is just the breakdown between 1A basis, which could be by foreign domiciliaries, or by any of the three other bases. And after the 1A basis, it's Madrid's or the second, the 66As are the most common to show up in an audit, but there's no attention being paid to anything about related to the country that an owner is domiciled in. It's not at all related to the software programming to create a randomized list.
The next one is, what is the relevant period during which there must have been use in commerce? If the mark was used in commerce 3 months prior to the opening date on which the Section 8 can be filed, and the Section 8 is filed that first day, is it acceptable to rely on use from the 3 months earlier than the 5th year anniversary? So use has to be within that statutory filing period, which should be the 5th year, to, you know, so your use would need to be within that relevant period, because again, you're going to have to provide us a specimen that's going to support use during the relevant statutory filing period. So it would be that 5th year, and then, you know, ending with the going all the way through to the grace period for use.
Can you please confirm how the number of goods or services being deleted is determined for cost fee purposes? For example, sometimes different goods in the class are separated by commas or semicolons, sunglasses and software versus clothing. Namely, will all the goods that follow namely be counted as one? Well, deletions are, it's a class-based fee. So no matter how many deletions you make in a single class, in a single filing response, you're just going to pay the $250 for the entire class. So if you have 50 items and you whittle it down to 2 and you delete 48, you're still paying the $250 for that class. And the deficiency fee is not at all related to specific goods or services or classes. It's an overall registration fee.
Jordan, you want to go ahead and take that one? I'm going to wait on another one for me. The very last one.
Sorry, I'm scrolling here.
Oh, sorry.
Monthly, that's okay. Are monthly or quarterly statistics on the number of audits and the number of office actions, et cetera, available on the PTO website or someplace else? Unfortunately, our trademark dashboard has yet to include audit data. Stats are typically made available in presentations. They have been in the past given by our executives at various conferences, but we do not have that on the trademark dashboard yet, though I hope we do get it soon.
Okay, So the next one, can all trademark owners expect an audit during the lifetime of their trademarks? We cannot promise that. We just say, you want to be prepared because you never know. It is completely random. And again, it really is the luck of the draw, if you want to call it that, as to whether or not your registration will be randomly selected for audit. But again, keep in mind, we're going to have these new mechanisms available soon, re-examination and expungement, where there's an opportunity for third parties and the director of the USPTO to look into, non-use and failure to use in commerce through those proceedings as well.
Just to piggyback off that, though, I had one more. I have another question here. You should think about the audit not just as a registration owner, but now is the time of filing of new applications, because there are multiple milestones along the way in the pre-registration process where you can make determinations about use in commerce. If it's a 1B application, when you get to that statement of use stage, you have an opportunity then to remove goods or services that maybe no longer have a bona fide intent to use. So think now that the audit program has been around for several years, it's really important to consider what is going into your application at that stage before you end up at a registration stage and you have to work backwards. All right, so this question is, if some goods are deleted on filing the Section 8 or 71 declaration, but later the client actually starts using those goods, can we later add them back to the registration, or do we file a new application? So once goods or services are deleted from a registration, they do not come back. You will need to file a new application for those goods or services.
So this one is a follow-up on the relevant use period question that I answered a moment ago. Following up the relevant use period, is the answer the same for the 9th and 10th year renewal? Absolutely. It's for every, the period thereafter. Every 10 years, the use should be within the relevant, that 10-year filing period or the 20-year filing period going forward. That's when your Section 8 or 71 declaration is attesting to use during that relevant filing period. And looks like...
Last chance.
Yeah.
So I think that's pretty close to all of them. I know that there are some questions that haven't necessarily been answered, but and so I know folks that you sent them in. They're not necessarily relevant to the topic today, so that's probably one of the reasons why the presenters aren't going to get a chance to answer them. But we pretty much hit all of them. I think a lot of the questions have focused on what is the best way for an attorney to help their client avoid paying all of those fees. And maybe it might be a good idea as we continue to wrap up today to really hit home maybe one more time, like what is the best way to help clients avoid paying those fees? Mantia, you want to take it?
Sure. I would, again, encourage you, right as you're approaching that relevant statutory filing period, be it the 5th year, be it the 10th year, the 20th year, check the ID, create a checklist, and set each good and service that's currently in your registration on a separate line. And then if you're the attorney, you want to work with your client to have them to look to confirm use of the mark with the specific goods and services that are in their registration. If they cannot confirm use, then as soon as they can, and again, before they file their Section 8 or 71 declaration, delete those goods and services if, of course, there's no excusable non-use claim that can be submitted. Proactively delete anything that they can't confirm use for. And that's really the way you, and then, of course, collect any evidence and hold on to that evidence and make sure any evidence that you have identifies use during the relevant statutory filing period.
Cool. Thank you very much. I have one more come in. I'm just checking to make sure and see whether it's one that we can ask. Jordan, do you have anything that you want to hit home as we close out today?
Call your audit examiner with questions. We try to be as helpful as possible over the phone or by email. And if you're just unsure about procedure, unsure about how to use the form, just to help get your submission through, give us a call. We want to help. We want to be as helpful as we can. can't provide legal advice, but we can certainly help you walk you through the process and get that response submitted. We don't want to see a registration get canceled because the response just couldn't get submitted for reasons that were otherwise resolvable. So please reach out. That's it.
One more just came in, Jordan.
All right, so we got here. Oh boy, that's a long one. If you are required to pay a deficiency fee, will you be informed ahead of time or must you anticipate that when submitting? Wait, do we already have this one?
Yeah, I think.
Okay. I think we answered that one.
Yeah, I think we got that one.
But yeah, you will only have to pay once in response. So you will get the office action that will let you know what fees are owed, and then you have to pay the fees in response.
How about, Jordan, the last part of that, which is what are the consequences of forgetting to submit the fee?
In the end, you're going to get to a stage where you're going to get a third office action that's going to require, this is a good question because we have not really gotten this yet with the fee rule. But at some point, the fee is going to have to get paid. And ultimately, if it's not, the registration is going to cancel.
Right. You'll get an office action or, to say, hey, you need to pay the fee. If the fee is the only thing that's outstanding, then we would issue that office action to say, we need this fee to, deletion fee, deficiency surcharge, etc.
Yeah, there is at some point a cutoff. We can't just get every 6 months a letter without the fee that we asked for and expect another office action is going to go out. At some point, there's a cutoff and that registration is going to get canceled.
All right, we have a couple more coming in. So hold on, folks. We'll try and get to them here. Well, actually, I can ask you this one, Jason. Or I'm sorry, Jordan, to sort of tack on. So what happens if your call is not returned when you're calling the examiner? What's the policy with regard to phone calls? Is there a 1 to 2 day business days, or what are we talking about here?
Sure. Yeah, we ask that calls are returned within 24 hours. So 1 business day. Email can be helpful as well. We all kind of work a variety of hours and are located in different locations. If you persistently have a hard time getting a hold of somebody, after several weeks, contact that person's supervisor. If you can locate that information on the website, or you can contact me or Montia. That is fine as well. If you're persistently having a hard time getting a hold of somebody and their out of office email is not provided instructions otherwise.
Okay, and I did get another one about use. Are you saying that use must be in the 9th, 10th year? In other words, you cannot claim use if it was used in year 6, but not since. That is absolutely correct. Yep. Use is during the relevant statutory period, whatever that statutory period is for maintaining your registration.
All right, so hold on. We might have one more we can sneak in here before we have to close out.
Oh, Jordan.
Okay, can you pay multiple deletion fees for deleting goods in the same class when deletions are requested following multiple office actions? Okay, if I understand this right, because I'm trying to think of the scenario this comes up. So frequently we will have a response with the fee rule in effect where the response makes deletions in a class, but the fee for that class is not submitted. So the second office action goes out and the audit is not satisfied. So that second office action will indicate that, let's say it's a 1 class, so a fee of $250 was incurred but not provided. And if you make any additional deletions in the second office action, you will pay the fee again. And so yes, in that response to the second office action, if you are making additional deletions, you will pay at a minimum the $250 initially occurred, and then the fees for anything deleted on top of that on a per class basis. And you want to pay all of that in your second office action. If that second office comes back, makes the deletions, but the fees are not paid, you're going to get another office action with the fee amount and that warning that if you don't respond to that with the fees, that the entire registration will be canceled.
And I have another one. How are requests for non-use handled during audit proceedings? So if the initial Section 8 or 71 declaration includes a non-use claim, it is actually kicked out of the audit because the purpose of our audit is to check the accuracy of use claims in a Section 8 or 71 declaration. On occasion, we do, I think, see non-use claims being submitted after an audit is underway, and we do evaluate those. And Jordan, I think generally you can help me out with this one. It'll come down to cases where they're saying, during the midst of the COVID pandemic, they would, respondents might say, we can't get to our warehouse to even check to see if we have good proof of use. So we would allow for the audit to conclude in those cases, because again, it's something that's beyond their control. And so that's a way where it's not necessarily non-use, but they're saying we can't prove to you that we're using it. And then in the cases where they're responding by then saying, actually, our mark is not in use, do you want to, in the context of an audit, do you want to handle what we would do in those cases?
Sure. Yeah. So there's two things that crop up a lot. We do have a COVID-related scheme for handling non-use specifically to requested proof of use because the goods or the more common services could not be performed during the pandemic due to perhaps to government regulations that affect the ability of the services being performed. That's a whole separate scheme where we have procedures for evaluating those claims and certain statements that have to be made to conclude an audit. However, we also do have a time where once an audit is started, if a non-use claim under the ordinary non-use rules is being made, a new Section 8 or 71 has to be filed. A response that simply actually creates that states a non-use claim is not sufficient, because you cannot file a Section 8 and 71 that you claim there is use and all of a sudden to be like, nah, there's actually not use. You need to file a new Section 8 or 71 to make that claim. That Section 8 or 71 will be reviewed outside of the audit review and will be handled under all the normal rules for excusable non-use.
And I have another one. What if you file a renewal during the regular period and you get an office action? Can you show use in the grace period? The answer is yes, because the grace period is also a part of the statutory filing periods.
All right, excellent. That appears to be all that we have, or at least all that the technology is allowing to come in at this time. So let's go ahead and close it out. So first of all, a big thank you both to you, Mantia, and to Jordan for hosting and for giving us all this great information. And I'd like to thank the crew, who's been great in terms of making sure all the tech has worked properly. And of course, thank you to all of you folks for attending today. You are going to be getting a survey, so please take a minute or two to fill that out. We really do look at the results, and we really do want to make sure we're giving you the best possible webinars that we possibly can. So please, if you can, take it a minute or two to fill that out. I also want to just very briefly tell you folks, I'm going to share my screen here real quick. All right, so just so everyone is aware, because the question always comes in, is a copy or a recording going to be available? The answer is yes. You'll be able to find it here on the Understanding the Trademark Post Registration Audit Program page. As you can see here, it's going to be posted here, and it's also going to be posted on the Trademarks Webinar Series page. So keep an eye out for that. And I also wanted to let you know that we have some additional fun stuff that's going to be happening. Commissioner Gooder is going to be doing a sort of fireside chat about intellectual property in the Olympics. That is on June 11th, and you can register early or register at any time actually before it begins to attend that. And if you have those TMA questions, by all means, join us for the roundtable. It is going to be, I believe, on the 14th. Yes, on June 14th. So please go ahead and sign up for that. And of course, obviously, most of you folks on this call today don't need a Trademark Basics Bootcamp, but if anybody in your organization you think might want a little brush up on all the Trademark Basics, by all means, please sign up and join us for the Trademark Basics Bootcamp. Or maybe even recommend it to some of your clients just to make sure that they are up to speed on all the things to make your meetings with them more efficient. If you haven't attended, it is an 8-week series, and we pretty much cover all the basics that you need to know, from fundamentals all the way through searching and through filing. I even walk through a TS Plus form. We talk about how to respond to an office action, and then as you know, so a lot of the information that Montia is an expert on, we talk about here in keeping your registration alive. So just want to point that out as another possibility of the sort of educational programming that we're trying to do to make sure that you have all the information possible. So we're going to close it out. We're just about on 4:30 Eastern. So thank you again very much for being with us today. And thank you again to Montia and to Jordan for sharing their knowledge with everyone. Thank you so much and have a great rest of your day.